Donald Trump is fighting to adjourn his criminal trial that is scheduled for March 25th in New York. Multiple felonies brought by this guy, Alvin Bragg, and their star witness is Michael Cohen. You remember him, the convicted perjurer who Trump's team says committed perjury again in the Letitia James trial, because they're just using this convicted perjurer as a starting point for all of these weaponized prosecutions against Trump. And this one is right around the corner. We know this is Judge Juan Merchan who's presiding over this, and he's explaining that trial is going to be going. This is kind of all hands on deck for the left. They know that the J6 case is not going to likely be happening this year. Florida's probably going to get bumped. Fani Willis is in trouble indicting her special prosecutor, and now this is all they've got. But Trump submitted a motion to preclude evidence and to adjourn this entire trial because of presidential immunity, because the Supreme Court is hearing that issue that worked its way up through Judge Chutkan's courtroom on the January 6th proceedings, and now Trump says it applies in this case. We see criminal case against Donald Trump. Supreme Court, State of New York, Bragg against Donald Trump. The defense, Trump writes the following: this is President Trump's motion to exclude evidence and for an adjournment. Why? Presidential immunity. They give us some background on this. They say, Your Honor, Judge Juan Merchan in New York, President Trump respectfully submits this motion for an adjournment of the trial. Why? Presidential immunity. We know the Supreme Court is set to review the scope of this, and they agreed to hear this case back in February. Oral arguments are going to be on April 25th, and we have that on our calendar. And two, they're also going to be considering, or ask the court to consider, whether they can preclude evidence of Trump's official acts at trial based on presidential immunity. So postpone the trial, right? Adjourn the current trial date. And when you're reconsidering this trial date, preclude evidence that is protected via presidential immunity. Here's some more. Trump says, all right, Judge Juan Merchan, who's very adversarial to the defense thus far. All right, Juan, this court must preclude Bragg from offering evidence at trial of Trump's official acts as the commander-in-chief. Can't talk about that. That's not evidence, which Bragg have not yet even specified as the existing trial date approaches in just 2 weeks. However, in motions in limine recently filed, Bragg argued that they should be permitted to offer evidence at trial concerning a fictitious so-called pressure campaign by Trump in 2018 relating to Michael Cohen. Now we're in Trump is president time, right? Clock starts 2017 when Trump is sworn in. Now, the people's motion in limine is what references this. So in other words, Bragg is saying, I want to talk about what Trump did in 2018 to pressure Cohen. And they say, sorry, that's president time. Now, although the people did not describe the evidence that they intend to offer in detail, so we don't even know what they're talking about, it appears that the evidence includes public statements by President Trump and posts to his official Twitter account, as well as testimony from unspecified witnesses. So we don't even know what it is they want, but apparently it's from his official president stuff. So the people's recent proffer, meaning Bragg, they came in, they told the court what it was going to be used for, but they can't use it. Sorry, it implicates presidential immunity because Trump was president when he made those statements and did those things in 2018. He made at least some of those 2018 statements at issue, and potentially all of them, though it's hard to be sure because we don't even know what they're talking about or what they want, in his official capacity as the chief executive of this country. And moreover, while it's clear that Bragg intends to offer documents and testimony relating to the period of 2017 when Trump was in office, they again have not provided sufficiently specific notice of the nature and the extent of that evidence to allow Trump or the court to distinguish between personal and official acts. So they just say, we've got this evidence we want to use against Trump, came from his Twitter, came from other areas, and Trump says, no, that's all my official stuff, which is the argument that we're making in January 6th case in Chutkan's courtroom. Within the outer perimeter of the official acts, immune. Congress doesn't like it, they can impeach the president, then shatter that immunity and convict him, which they didn't do with Trump. So such distinctions are necessary and complex. We have to get into this. And so we can't have this trial if we don't know what evidence they're using, as illustrated by the DC Circuit's recent guidance in Blossingame. In that case, the panel emphasized that Trump is provided every opportunity, he's entitled every opportunity to present his defense. And this area of law, Judge Juan Merchan in New York, is evolving in real time. So how can we have a trial when we don't even know if some evidence is immune or not? Now, specifically on the 28th this year, SCOTUS granted cert, and they're going to answer the following question when they decide. Question: whether, and if so, to what extent does former presidents enjoy immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? So do you see what Trump is doing? They are sneaking this in, right? We don't know. Alvin Bragg has a bunch of different evidence. We don't know. Some of that official, maybe. Some of it's not, maybe. But we don't know because they're not telling us what it is. So therefore, we can't have a trial while the Supreme Court is talking about protecting official acts, providing immunity like a force field around them. They say, in addition, Judge Juan, on March 4th, a unanimous Supreme Court also, oh, this hurt for Judge Luttig, pour one out for Judge Luttig, sorry, loser, held that the Colorado Supreme Court had erred by excluding President Trump from the Colorado 2024 presidential primary ballot. 9-0. Oops. The Anderson Court reasoned, in part, that states' power over governance does not extend to federal candidates. The court's emphasis on federalism principles further supports the timing of this motion and is relevant to the application of presidential immunity because any effort to retaliate against the president for official acts would be an unconstitutional attempt to influence a sovereign superior exempt from those obstacles. If the president is beholden to like the federal courts or suing him to do this or to do that, or a prosecutor is prosecuting him to do this or to do that, he's kind of subordinate to those people, right? Which is why we have immunity to protect and insulate the office. So therefore, they say, President Trump respectfully submits that an adjournment of the trial is appropriate to await further guidance from SCOTUS, which should facilitate the appropriate application of the presidential immunity doctrine, in this case, to the evidence that Bragg intends to offer. Now, after we get the Supreme Court decision and consistent with the remand, the court should hold a hearing outside the presence of this jury to identify and preclude documentary and testimonial official acts evidence that's based on presidential immunity. So some of the stuff that they're seemingly going to introduce is presidential, might be official acts. We don't know. We have to decide. So we have to have a separate evidentiary hearing where we'll present evidence of that and then we'll break it all down. So here's what they give us. Trump's team tells New York Judge Juan Merchan that as far as we can gather from the description of Bragg's so-called pressure campaign that he's going to seek to introduce into evidence, in their motion, there are several types of evidence that implicate the concept of official acts for the purposes of presidential immunity. If Trump was acting inside the outer perimeter of his official duties, presidential immunity applies. It's the hula hoop. If he's outside, it doesn't. So they say, well, if that evidence is inside, and we think it is, because this is what they've told us, it has to be precluded. If we have trial coming up while SCOTUS is still weighing this, then you can't talk about that. We don't know. It might be illegal. Here's what we've got. First, President Trump used his Twitter account, which was an official communications channel during his presidency. And he used that Twitter account to communicate with the public about matters of public concern. And in 2018, some of those matters included Michael Cohen. FBI executed search warrants that targeted him. In April 2018, President Trump posted messages on his Twitter account. He said the following. He said, quote, "Michael's a businessman for his own account and lawyer who I have always liked and respected. Most people will flip if the government lets them out of trouble, even if it means lying or making up stories. Sorry, I don't see Michael doing that despite the horrible witch hunt and the dishonest media." Trump also said in 2018, May, he said, "Mr. Cohen, an attorney, received a monthly retainer, not from the campaign and having nothing to do with the campaign, from which he entered into, through reimbursement, a private contract between two parties known as a non-disclosure agreement. These agreements are very common amongst celebrities and peoples of wealth. Money from the campaign or campaign contributions," Trump said, "played no role in this transaction. All above board, nothing to even worry about here. Leave me alone." On August 22nd, Trump also said on Twitter, he said, "I feel very badly for Paul Manafort and his wonderful family. Justice took a 12-year-old tax case, among other things, applied tremendous pressure on him, and unlike Michael Cohen, he refused to make up stories in order to get a deal. Such respect for a brave man," says Paul, or says Trump on behalf of Paul Manafort. And second, President Trump made public statements on official premises during media appearances. So Trump went out, he said this, April 5th. During statements to reporters on Air Force One, Trump directed reporters, he says, "Ask Michael Cohen about the allegations." Added, "Michael is my attorney. You'll have to ask Michael Cohen." April 26th, during a phone call, says during a telephone call aired on Fox and Friends, Trump explained that Cohen, quote, "has a percentage of my overall legal work, a tiny, tiny little fraction, but Michael would represent me on some things. Like with this crazy Stormy Daniels deal, he represented me. And from what I see, he did absolutely nothing wrong. There were no campaign funds going into this at all." Trump also said on August 23rd, during an interview on Fox and Friends, he said, "If you look at President Obama, he had a massive campaign violation, but he had a different attorney general, and they viewed it a lot differently, you know. We have somebody that they seem to like to go after a lot of Republicans, but he settled his very easily. In fact, I put that out fairly recently. So Obama had it, other people have it, almost everybody that runs for office has campaign violations, but what Michael Cohen pled to, they weren't even campaign related. They weren't even crimes. So Trump's defense is pulling those out. They are now saying third. Bragg also seems to want to offer other evidence that reflects official acts, and the category appears to include a form that Trump submitted to the U.S. government office. Fourth, it also appears that they're going to try to elicit testimony at trial that relates to official acts. So for example, redacted is on the people's witness list. Uh-oh, who's that? During grand jury testimony, so-and-so said this, and then they said this, and then they said this. Oh my gosh. And similarly, they said this. According to so-and-so, that's what happened. Wow, I know. Shocking. So here, after all of that, they say, look, summarizing, they say Alvin Bragg doesn't tell us what his case is. We still have a lot of questions about what the evidence is. He doesn't have to give us the theory of his case or tell us exactly what he's doing. But based on what it sounds like he's going to do, he's going to get a bunch of official acts stuff in here. We think we're immune from that. You can't say that we're not immune from that because the case is currently pending with SCOTUS. And that means you can't have this trial and use that evidence at the same time because that evidence might be immune. It's pretty smart, pretty brilliant actually, right? We were trying to think about how they can delay this trial, and now they're just grabbing onto a little bit of evidence that Alvin Bragg brought up and said, sorry, if you're going to talk about that, well, we got to wait for SCOTUS, man. SCOTUS is going to take some time. So you got to delay your trial. Here's what Trump's team says. Here, Trump is immune from state prosecution based on official acts. Say, under the executive vesting clause, state courts and prosecutors, they cannot sit in judgment over a president's official acts. We're very familiar with this argument. If they can, if someone else can sit in judgment over their official acts, they're the president, right? They have more power than the president. If Trump needs to fill out a form to declassify something, who really has the declassification power? The president or the person who reads the form? Okay, so the president does. So you can't usurp that. Now, that's exactly what they're trying to do here, saying in Marbury versus Madison, the president is invested with certain political powers, and he uses them at their discretion, his or her discretion. The acts are only politically examinable, and they can never be examinable by the courts. So how can Judge Chutkan sit in judgment over something that Trump did officially, which was to investigate our rigged elections? SCOTUS is going to tell us. They say the Supremacy Clause also prohibits state and local officials from trying to use their power to defeat their legitimate opponents, saying also presidential immunity from criminal prosecution also comes from the Constitution. The Impeachment Judgment Clause also says a president cannot be criminally prosecuted for their official acts unless they're first impeached and convicted by the Senate. It's literally the same arguments in the J6 case. Yeah, if you wanted Trump to be convicted or prohibited from running again, disqualified, got to actually impeach and convict. If you think that you can prosecute him in a different court, you got to impeach and convict. It shatters that immunity. Now, this was the understanding of our founders. James Wilson participated at the Philadelphia Convention. The president is amenable to the laws in his private character as a citizen and in his public character by impeachment. Alito made the same point, and we've referred to Federalist number 65 many times here. The president requires immunity in order to do their job. Without immunity from criminal prosecution based on official acts, the president's political opponents will do exactly what they're doing here today. They'll seek to influence and to control his or her decisions via de facto extortion or blackmail with the threat of prosecution. The threat will hang like a millstone around every future president's neck, distorting the presidential decision-making and undermining their independence. So they say history also tells us that this is important. There was an unbroken tradition of not exercising the criminal prosecutorial power of presidents for official reasons. Why? The power doesn't exist. 234 years until we got here. History abounds with other examples of presidents who could have been prosecuted if they had Tishy James and Alvin Bragg and Fannie Willis and Jack Smith. John Quincy Adams, he made an alleged corrupt bargain, appointed Henry Clay as Secretary of State. Bush lied to Congress and all of us, said that Hussein possessed stockpiles of weapons of mass destruction. Remember that garbage? Thousands of Americans dead. Obama authorized drone strikes, killing U.S. citizens, and his teenage son just took them out, no problem. They also include Clinton. He pardoned Mark Rich. He used airstrikes in the Middle East to distract from Monica Lewinsky. Prosecute him. How about Biden's egregious mismanagement of the border? Biden's alleged material support for terrorism. He funded the UNRWA despite its history of direct support for terrorism. How about billions of dollars that he's giving over to Iran? It's blowing blowing people up all over the world. Now, despite numerous examples of presidents allegedly committing criminal behavior, no one's ever prosecuted them before. Not in 234 years. Not until Trump. Now, other immunity is given to other people, obviously. Congress has it. Judges have it. We're familiar. Members of Congress are immune from criminal prosecutions. Judges get it when they're in the scope of their legislative duties. And public policy supports this as well. Presidents need to act with bold and unhesitating action. And if they're constantly tiptoeing around whether they're going to get prosecuted by Fani Willis, they're not going to be able to do their job. And so in this case, we have to adjourn this trial. Now, we can't do it right now. Now, while the concept of presidential immunity is firmly established, we know that we talk about it, the doctrine's scope is a serious and unsettled question of law. And so therefore, this court, Judge Juan, should adjourn this trial until the Supreme Court resolves Trump versus United States. They say, now, while adjournments are ordinarily committed to the sound discretion of the trial court, in some situations, when the protection of a fundamental right has been involved in requests for an adjournment, that discretionary power has been narrowly construed. This is just outstanding. So they're trying to pull this case away from Juan Merchan, just like they did with Judge Chutkan. They pulled this maneuver literally with Judge Chutkan, saying, since we're appealing this, you no longer have this case. We're taking it from you now. They're getting very close, saying, Judge, you don't have the discretionary power here to deny this. Very narrowly construed. Like, you do, but you got to really think about this. You might have to adjourn this. Why? Because of the importance of the presidency in the constitutional order, as well as the supremacy clause and related federalism principles implicated here, the adjournment, the postponement, is warranted here to ensure proper adjudication of the presidential immunity defense and to prevent improper evidence of official acts, which might be immune, from being used in an unprecedented fashion, never before seen, by Bragg, waiting to try this case until after SCOTUS addresses this question. And by the way, oral argument is just next month, just right around the corner. It's going to simplify the application of these evidentiary issues here. Now, we've discussed this below. We have questions about the scope of official acts. It's a developing area of the law. We don't really even know what it means. And so this adjournment is going to avoid the unnecessary risk of inconsistent adjudications. You might say it's not immune. All that evidence comes in. SCOTUS comes out, says, sorry, immunity applies to all that. We don't want to have to reopen this case and do this all over again, do we? By President Trump, it relates to his immunity. And so the adjournment would mitigate the risk that an error in the application of this complex issue, it would expend resources and we would have to retry the case, right? You don't want to do this all over again, do you, Judge? Do you? No. So just wait. Say Bragg must be precluded from offering evidence of this. It's official acts, so it's protected. Saying the presidential immunity doctrine is capacious by design. Trump's entitled to immunity for everything that falls within the outer perimeter. The president's actions do not fall beyond the outer perimeter of official responsibility merely because they are unlawful or taken for a forbidden purpose. Supreme Court has even said that. And so the court must preclude this evidence. Sorry, Alvin. In assessing whether immunity applies, the court must look to the nature of the act itself. There's not always a clear line between this. What's the difference between personal and official? The question is whether the action can be reasonably be understood as official. Now, this inquiry does not consist of trying to identify speech that would benefit a president politically. When an appropriately objective and context-specific assessment yields no clear answer in either way, the president, in our view, should be afforded immunity. So it's a protective doctrine. Now, in the current posture, this requires the court to preclude Bragg from offering into evidence Trump's official acts. For example, in Johnson, the Supreme Court held that they couldn't use stuff in that case. And under those standards, Trump's social media posts, his public statements, all the stuff when he was president, those fall within the outer perimeter of the presidential duty. And if you don't understand how it works specifically, you can delay this case until SCOTUS decides. And if it's questionable, tie goes to the defendant. You give them the immunity. Tie break goes to the defense. They say Trump's statement in April of 18 from Air Force One is a powerful example of why context is important. He was on Air Force One. And with respect to his social media posts, the official act's conclusion is also supported by the fact that his Twitter account was one of his main vehicles for conducting official business. Second Circuit has held that the official nature of the account is overwhelming, right? First Amendment. Now, the Office of Government Ethics, established in 1978, they say all of Trump's communications were regulated. So since they're regulated, those are also official acts as well. And finally, wrapping this up, they say there is no constitutionally significant distinction to be drawn between documents and testimony for purposes of presidential immunity. Thus, the court must must preclude Bragg from eliciting these testimony and other testimony disclosed by this person and by this. Same rules apply for these witnesses and others. This, as we can see, is signed by Todd Blanche. It says, for the foregoing reasons, the court should adjourn the trial, review the scope of presidential immunity, let the Supreme Court decide, then have an evidentiary hearing to distinguish what is personal, what is presidential, what's inside the hula hoop, what's outside, and then preclude all of the evidence of Trump's official acts at trial based on presidential immunity. So this is going to be very interesting. And I think Judge Juan Merchan is going to do everything he can to deny this request and keep the trial on track. I think he'll just probably say it's all not official and allow the trial to stay on path, because if he delays this past the SCOTUS oral arguments, he's going to run into the same problem that Judge Chutkan has. In other words, they're both going to try to get their trials back on the calendar simultaneously, and they're going to run into problems because now we're getting close into election season. So I'm not sure it's a motion that they'll win on ultimately. Whether those acts were presidential or not, my understanding is actually some of the payments to Cohen were also done in 2017 when he was the president. So we have questions now about whether there will be a test about what is included and what is excluded. And you could make the argument as well that this actually might hurt him in the Supreme Court case, because it might cause some justices to say, see, if we grant him immunity, he's going to use it even for that stuff. Like he's going to use it in a scope that's bigger than they intend to use it. But, Supreme Court's going to decide a lot on this. I think they are going to find that there is presidential immunity. Now, the test, right? How do you define what the hula hoop is? And how do you declare what's inside, what's outside of it? That's going to be the big question. But it's a very interesting filing. I think that the takeaway here is that they have identified something that is clearly, that they can latch onto. Like, this is what defense attorneys live for. And so it's a beautiful maneuver. Whether Judge Juan Merchan follows the rules and slows things down and allows SCOTUS to make a determination on this before going to trial, I doubt that happens. I think he's going to just try to keep this train on the track for the sole purpose that they're running out of time and they got to get this thing done. So speaking of the onslaught that's happening in New York, Andrew Weissman is out now, and he wants to know who is helping Donald Trump. Okay, these people just can't ever let up, ever. It's nonstop with them. So, they secure a $91 million bond from Trump. He posts the bond. It's like they want blood from a turnip, He posts the bond and they say, that's not good enough. Where did he get the money from? And so Andrew Weissman showed up on MSNBC's hit show called Inside Jen Psaki, and here's what he had to say.
You tweeted, my guess, Trump may have someone like Elon Musk co-signing the Chubb bond, so the bank is comfortable being on the hook for the judgment. Same could happen for the bond for the AG $450 million judgment. Can you explain to us what you mean, how that works, what you think is happening here?
Well, listening to your first segment, Jen, about whether Donald Trump is going to be successful in running as an outsider, this is an example of his running not just as an outsider, but as an outlaw. And, not just the criminal cases, but you have these civil cases where he has judgments. He has two up to $91 million in the E. Jean Carroll case, and obviously the $450 million in the New York fraud case. And the concern in these civil cases with these civil judgments is, who is the candidate beholden to? Is he somebody who is going to be making policy and being deferential to people who have put up money?
You think it's Putin?
There's a simple way of looking at this, is he has 450 million reasons to be deferential if somebody else is putting up the money or co-signing. So for instance, Elon Musk, I'm not saying he is the co-signer, but he has said, I have not given up money. But that's not the only way that you can help Donald Trump get a bond. He can actually co-sign it. And so that issue of who is actually behind this is something that people who are voting should know.
All right, so it's never ending, right? It's just constant. He gets 91 million. Where'd that come from? Must be Putin. Can you get that from the Saudis? Jared Kushner do it? Then they're like, he's a billionaire, so he's got plenty of money. Where's the money? Where's the money? Where's the money? He comes up with the money. Where'd he get the money? It's never ending with them, right? It's a double standard, as we know. Byron Donalds is here to explain what is ultimately happening. Obviously, Joe Biden has committed crime after crime after crime. His son has a whole book of, his best, greatest hits up there. And Byron Donalds, says, why is there a double standard? Why does Trump have to play by a different set of the rules? You keep saying that no one's above the law. Clearly, tons of people are above the law. Donald Trump isn't. Donald Trump's below the law. He has no protections. His right to counsel, his attorney-client privilege is shattered. He gets indicted when no one else does. The list never ends. Here's Byron.
House Oversight and House Judiciary are doing our jobs. We are requesting the information from the special counsel on his investigation into Joe Biden. And let's be clear, this is not not about Joe Biden's activities during his presidency. It is the fact that he did take classified information from a secure facility when he was vice president and when he was a United States senator. Both are a violation of the Espionage Act. And having a poor memory does not absolve you from violating the Espionage Act. Being old and elderly does not absolve you from violating the Espionage Act.
Apparently
and
it does.
Once again, you see the two-tier system of justice against Donald Trump simply because he is the Republican nominee and he is actually the person that would blunt the radical Democrat agenda. So what do the Democrats do? Weaponize the Department of Justice, go after their political rival. It is fascism here in the United States brought to us by Joe Biden and the Democrats.
Shout out to Byron Donalds. Nice statement there. And he's absolutely right about it. How'd those documents end up in Joe Biden's garage? How come Hunter Biden's memos to his comrades in Burisma in Ukraine, how come they all mirrored a lot of what sound like official SCIF documents that Joe Biden would be looking at as the senator? No charges, nothing. But Donald Trump gets implicated every which way, and they drag out people from the gutters to file civil lawsuits against him. Nonstop. Byron Donalds calls it what it is, fascism in America, and he's right. So that, my friends, of course, is Donald Trump fighting to adjourn the criminal trial in New York. We'll see if that happens. I think it's a very interesting maneuver. We're anticipating quick replies, quick rulings on this, probably a quick appeal, and we'll see if the trial stays on track or if it moves onward. Either way, we're going to be here covering it and the rest of the Trump prosecutions and trials and SCOTUS appeals and ballot removal attempts or whatever else comes next. We're going to be here, my friends. Thank you for joining us as we do. Thanks for also checking out some of the links down in the description below. We have a great event coming up, watcherlodge.com, absolutely free. Would love to have you come and join us. It's a Saturday 2-hour event. It's going to be fun. We also have robertgovea.com if you want to grab the PDF we just read through. Links are in the description below. And of course, our members only community where we do live streams in the morning. We do streams on Saturday and we do after parties after our live show, watchingthewatchers.locals.com. We'd love to have you join all of us everywhere. But if we don't see you there, we'll see you right back here on the next one.